Hi, welcome to another Cannabis Industry Lawyer, where I explain the marijuana laws so that you can change them. How do you protect your cannabis IP, knowing that the Controlled Substances Act is basically fucking with your shit? You're going to want to stick around to the end for that one, because that's where I'm going to tell you one common law trick to protect your cannabis business's rights. The U.S. Patent and Trademark Office won't allow your trademark for a specific strain of cannabis or for anything really directly related to cannabis. The reason for this should be fairly obvious by now if you've been joining us before in the Cannabis Industry Lawyer. The reason is it is a controlled substance. It is right next to heroin as a Schedule I controlled substance. Interestingly enough, Congress could end all of this tomfoolery right now with just crossing it right out and striking it from the Controlled Substances Act, but they will not. And as a result, you cannot get a federally registered trademark for your cannabis brand. Further, what about your paraphernalia? You have your brand, you slap it on your pipes or your nails or whatever piece of stuff that you need to use your cannabis paraphernalia, which again is not really the best word for it, but the stuff that you need to use your cannabis. Your pipes, your nails, maybe your grinders, wherever you store your cannabis so that it is kept at the appropriate humidity level. Those types of things also are going to run afoul of federal cannabis law, and you're not going to be able to get your trademark for them. How can I say this with any degree of, wait for it, this is an SAT word, kids, verisimilitude. Sorry if I mispronounced verisimilitude. But there is a recent case called In Re Morgan Brown. A company called Herbal Access wanted to register their trademark for a retail store featuring herbs. The USPTO, the United States Patent and Trademark Office, obviously, totally denied their registration for the mark based on a two-part test. There's one thing that you need to know about law. It's all about tests. Two-part test to invalidate your registered trademark for a cannabis business. First, finding a violation of federal law is indicated by the application record or other evidence, or B, when the application's relevant activities involve per se violations of federal law. So we're going to talk about A, we're trying to get a registered mark for Herbal Access, and the USPTO goes, let's look at this application, Herbal Access, and it's clearly for a marijuana retail store. Okay, fails that one, and it's in the alternative, so failing one is failing both. Sometimes the tests in law require an and. Not this case, because the Herbal Access mark still would have failed. Why? Because when the USPTO is looking through the applicant's relevant business activities, it would have gotten a per se violation of the federal law. They'd be looking at it and going, oh, so part of your business is selling a Schedule I substance. I'm sorry, I'm not sure why you applied for a trademark at the U.S. Patent and Trademark Office. You basically said, can we please trademark our particular brand of drug, which is a federal crime? No, you cannot. So, what can you do? What can you do to protect your state law compliant cannabis business's trademarks? Maybe your state has its own trademark laws. I know, right? If Congress would just get off its duff and strike one line through the Controlled Substances Act so that cannabis isn't in it anymore, we wouldn't have to be having this conversation. So, let's recap what we've gone over about your cannabis business's trademark IP. First, good luck with the USPTO. Second, check your state's laws, especially if your state allows legal marijuana, there's a good chance that you will be able to get some trademark protection for your business, provided that it is complying with state's law. And now I'm going to tell you the common law trick to get protection even at a federal level. Thanks for sticking with us this far. And if this is your first time joining us on the Cannabis Industry Lawyer and you're enjoying the content, I hope that you will subscribe, because you will continue to get all this knowledge about cannabis laws so that you can change them. Now let's get to the simple trick about common law trademark protections. There is no lawful use requirement for the common law trademark. You can still bring a claim under Section 43, parens A of the Lanham Act to protect against infringement of your cannabis business's trademarks by third parties. There's no lawful use requirement of the common law trademark under Section 43 of the Lanham Act. However, you're requesting a federal court carry into effect a federal law which directly contradicts another criminal federal law based upon public safety, and then you're going to have a public policy argument which might just... And that's why you do have a common law trademark under the Lanham Act that's federally protectable, perhaps, but good luck trying to get it enforced by the USPTO until we strike it from Schedule 1. Hi, I'm Tom, the Cannabis Industry Lawyer, and thank you for joining me on another episode.